tell him to be quiet, because in Minnesota, that violation of the rules. Now, the juror was already, the judge told that person to do that. So, he's not supposed to be doing that in the first place. But in Minnesota, there's a special obligation on the attorney neighbor to put an end to that. So watch out for that. Like I said, the neighbor has already been told not to discuss the case with third parties and use a third party. But in Minnesota, there's a specific ruling here about that. And I bet we could probably squeeze that to one of the hour rules too. You're not supposed to be. Question?
Well, in this ex-parte communication problems, how about in the domestic relation area, in which you've got children who are old enough to know what's going on, and there's no guardian ad litem for the children. They're living with the opposing parent. Who talks to them?
Well, in fact, that was, I think the other who asked that question was not, but he asked actually the same question. And his routine practice was that, he doesn't see anything wrong with that. So he is representing the non-custodial parent, interviewing the children who are living with the custodial parent. I think it's okay. Now, unless under the substantive Iowa family law, if there's a restraining order or something, But just in general, as long as that non-custodial parent has permission or has the authority to say, yes, you can talk to my children, as long as that parent, as long as your parent has that authority, I would say it's fine. In fact, if other attorneys take a position that no, you cannot talk to them, well, then they are probably the ones violating Rule 3.4 by unfairly obstructing your access to evidence and maybe requesting that someone other than a client not voluntarily give information. Except that one, there's an exception because that's a relative of the client. So I guess they're not violating that, but they're probably violating that first part. So I would say, unless there's some substantive law saying that you can't talk to them in this situation, I don't see how that would be a violation for you to interview them. Like I say, as long as your client has, under the substantive law, has authority to say, say, yes, my kid, you can talk to Santa Claus, or you can talk to this person, or you can talk to my lawyer. So maybe the custody order doesn't give them that power, but if it does, we say yes. Okay, so that's Rule 3.5. 3.6 talks about trial publicity. Now, normally when you think about trial publicity, you think about criminal cases. And in fact, when you read these provisions, most of it's talking about criminal cases. But these trial publicity rules apply to any jury case. So you have to keep them in mind. Even in civil cases, you have to be careful what you say to the press about your pending civil cases. And you're, in general, not allowed to if you think that it will be publicly disseminated and there's a substantial likelihood that it prejudices the case. They're kind of a vague definition. But just be careful in civil cases. You have to be careful what you tell the press. Now, then there's a list of things that are presumed to be prejudicial, and most of them talk about criminal cases. If you do any of the things on the list, number 1 to 6, are presumed to be prejudicial, and you have to watch out for them. And most of them are talking about criminal cases, the criminal record of a party. Most of the cases are going to criminal records, sometimes they do. Keep in mind, just because it's explicitly listing those things, that still lies even to a civil case.
And it's a stupid question, but there's subject 4, and ambiguous to guilt or innocence. What does that mean?
I think it's referring mostly to the prosecutor, saying the prosecutor should say, I have filed charges today in the district court, and I think the defendant is guilty. He should add that other part.
But why? He thinks that he's guilty. He brought charges. It doesn't make sense to me. I don't understand that.
Well, because it's his personal opinion, you know, because, yeah, I mean, you're right. Yeah, well, I mean, it's kind of like the rule that, you know, if you're, you know, arguing to a jury, you're not supposed to express your personal opinion, you know, you as the attorney should not say, I think my client is innocent. You know, what you're supposed to say is, the evidence has shown that my client is innocent. And the theory behind this, because again, lawyers are held such high esteem in the community, that just the mere fact that you as an attorney say, I think this is true, the whole world will automatically accept that as just the definitive truth. Well, I don't know, maybe, you know, yeah, the prosecutor's not supposed to say that. Now, I guess the defense attorney is not supposed to say it either. Now, I'd like to see an attorney charged with that, saying, I think my client is innocent. You know, in a TV interview. Yeah. You know, but the prosecutor, I mean, he's a public official, so I mean, he doesn't really have the First Amendment rights to speak on his behalf. So, or it is professional has to be, whereas you do. But I mean, that's what, yeah. But I mean, that's presumed to be prejudicial. So watch out when you're talking to the new people. Well, you know, and me is kind of a, you know, libertarian leanings. I mean, I kind of have my, I have some problems with that, saying that, you know, I'm not allowed to, you know, prejudice the jury pool. Well, that's why we have a First Amendment, so I can go out there and prejudice the jury pool, you know, because, you know, within reason, maybe. So, yeah, so I'm not sure I totally agree with that, but that's what the existing rule is. So just be careful, or at least be prepared for the consequences if you do want to make public statements like that. Okay, yeah, and here's what you are allowed to say on the next page that are kind of deemed not to be prejudicial. Well, anyway, Rule 3.7, in general, you as a lawyer are not to be a witness. Again, theoretically, the rationale behind that is that, you know, lawyers are held in such esteem that it would just be totally unfair to the other side, that they would believe everything said. Maybe there are other reasons for it. But the only exception is if there's some major hardship, a surprise situation, or a little uncontested thing, you know. So like affidavit of service. You're testifying. Okay, I swear I did this. Well, that's a non-controversial contest issue. That's permitted, but you can't testify in a case in which you are an attorney. If you're a prosecutor, then Rule 3.8 kicks into play. You have some special responsibility. You don't have to think the person's guilty, but you have to know the case is for probable cause, and it's a violation to bring a case not supported by probable cause. You have to make sure that you have to be a little bit proactive, make sure the defendant is entitled of his right to be an attorney. And one that kind of, you know, maybe causes more problems than good is the prosecutor will not, like, you know, you as a prosecutor, if you're dealing with an unrepresented defendant, well, obviously you can give legal advice to that unrepresented defendant, because you're not his lawyer, you're state's lawyer. This rule goes a little bit further. It says, you shall not seek to gain from an unrepresented accused a waiver of important pretrial rights. Well, that means if defendant is not represented by an attorney, it's practically impossible to engage in any kind of plea bargaining. Because at some point you have to ask the client to waive the right to trial. So I mean, it makes it difficult, if not impossible. Interestingly, Wisconsin, their reputation in Minnesota is that they make most of their state revenue from speeding. So I don't know if that's kind of the reputation they have. So it's interesting that they have special provisions for municipal prosecutors. So I presume are the people who are prosecuting speeding tickets. And they are exempt from this rule. It's clear that they can plea bargain with an unrepresented defendant. But a prosecutor, if I were a after reading this, I would talk to an unrepresented defendant. Is setting yourself up for trouble and accusation that you were illegal advice. That's legal. Because if I tell I'm the prosecutor, I tell the opposing attorney, well, if you plead A, B, and C, the judge will do D, E, and F. Well, that's legal advice. Because he might not. And the opposing attorney can still that, but the unrepresented can't. So you have to watch out. Don't subpoena a lawyer to testify before a grand jury against a client. It's just going to be not going to be able to testify anyway. So that's the responsibility of a prosecutor. Advocate and non-advocate. So you go to the legislature to testify in favor of something. Something that's going on in the legislature, you go there to testify, or an agency is doing some rulemaking, and you go testify or present argument about it. If you're just for the concerned public citizen, good for you. But you are there on behalf of a client, you have to disclose the fact that you are there on behalf of the client. So you can't go to the legislature and testify in favor of this reform of the law without disclosing the fact that your client will benefit from that reform of the law. So you can't pass yourself off as a concerned citizen when you're really just lobbying for your client. So I get this through Rule 3. Yeah, some of these other rules go a little bit faster. Rule 4.1, a lawyer has to be truthful in statement of evidence. Well, who could argue that? In the course of representing a client, a lawyer may not make a false statement of material facts to a third party. Well, that seems reasonable. Well, and he's going to have to disclose facts but, well, are you sure that's a good rule? Wisconsin has a couple of exceptions that maybe would be the exception of other states as well. And so one of those is if somebody is working for you and you want them to be, it's okay for them to engage in lawful investigative activity, even though they're not truthful. So, for example, the example they give is you have a discrimination case. You have African American clients who went to rent an apartment, and they said, no, we don't have any apartments. And you think your client was discriminated against. Well, one pretty good way of getting evidence of that is you hire two actors. You hire a white actor and you hire an African American actor. And you have the white actor go in and say, we would like to rent an apartment here. Say, why, yes, we have a vacancy. And then the African American comes in and they say, we'd like to rent an apartment. I'm responsible. Well, that's pretty good evidence of discrimination. Now, does that violate Rule 4.1? I don't know. A lawyer not make a false statement. Well, that includes people working for you. So these actors you hire go in there. They said, I want to rent an apartment. That was not true. They do not want an apartment. They were there for purposes of seeking evidence. So anyway, the Wisconsin rule makes clear that that's an exception. That is permitted. And probably that's okay in other days, but
I would think this is a real problem in the electronic age too, where people have usernames in Facebook and they start talking to people and chat rooms and various other things, and going back that they're investigating for a particular case.
Yeah. Well, and also that brings us right into 4.2 and 4.3 because that deals with your communications with the department. If the person is represented by an attorney, then you're not allowed to talk to them, even under your false Facebook identity. So I mean that would clearly be a violation. Basically, you're not once they're represented, you can't talk to them directly without going through the attorney. But in a case of an unrepresented person, you don't have to be as careful. But you have to be careful in communicating with them, including on Facebook. If the person, if you